important that we continue to optimise this funding opportunity and collaboration across the North for tourism with our other priority sectors. My department will continue to work closely with Tourism NI and with Newry Morning Down Council to ensure strategic planning and guidance for the development of the tourist industry. It builds on the Carlingford Lough Review and Master Plan, including the potential for destination stewardship support as outlined in my Tourism Vision and Action Plan. Tourism NI officials are working closely with Fáilte Ireland to ensure the tourism elements of the allocations as part of that programme complement one another on each side of the border, maximising the additional accessibility that the Narrow Water Bridge will provide to the area. And I think there are a number of key elements that the destination programme can support in terms of the networks and trails and water access points. So it's something that I think that we can certainly maximise to the benefit of the whole region.
Dennis.
I thank the Minister for her response. Minister, you recently met with the Chief Executive and senior officials from Newry Morning Down Council to discuss potential tourism projects in South Down that will, as you say, complement Narrow Water Bridge when it is completed in 2027. Does the Minister agree that investing in Kilbrony Park, for example, and the restoration of Warmpoint's iconic baths will be transformative projects with the potential to boost cross-border visitors and drive local economic growth?
Minister.
Yeah, and I thank the member for her question. My department is continuing to work closely with Newry Morning Down Council to develop projects that actually complement the completion of Narrow Water Bridge, and I think the projects that the member has spoken of, both in Kilbrony Park and in Warmpoint Baths, could deliver significant cross-border benefits in terms of growth of our visitor numbers and wider economic benefits, and we will be happy to continue to work to support those aims.
Thank you. That concludes questions to the Minister of Economy. We now move to Minister of Justice. Question number 1 is withdrawn. I call Patsy McGlone.
Ceist Everado, I can call you.
With your permission, Mr Speaker, I propose to answer questions 2 and 7 together. Whilst I welcome progress in addressing legacy issues and firmly believe that victims are entitled to expect transparency, truth and justice via a process that does not introduce further delay, concerns remain about the feasibility of the current proposals in terms of the degree of legislative scrutiny afforded the proposals and, crucially, how they will be funded. On the 11th of November, I laid a legislative consent memorandum to advise the Assembly that I am not laying a legislative consent motion, at least at this time, as I cannot currently recommend that the Assembly provides consent for the transferred matters in the Northern Ireland Troubles Bill. I did so on the basis that there has been a lack of meaningful engagement by the UK Government on the detail. I do not have the departmental resources to implement a UK Government policy over which I have no control without abandoning our agreed legislative programme. I also cannot move an LCM without the consent of the Executive, which has not been achieved to date. However, the necessary engagement is underway. Furthermore, and crucially, the UK Government has never adequately resourced legacy, and this has not changed with the introduction of the bill. Indeed, there appears to be no additional UK Government funding proposed for the Northern Ireland Executive arising from the outworkings of the bill, despite significant resource implications flowing from it. Given the potential implications for my department and wider justice bodies, and the fact that all executive departments are already under significant financial pressure, it is not reasonable to expect that additional costs can be met from existing Northern Ireland departmental allocations. I will, however, continue to engage constructively with the UK Government with a view to ensuring that the provisions in the bill are workable in practice, properly funded and resourced, and that victims' needs and rights remain central in any future arrangements.
Mr McGlone.
Thank the Minister for her answer. And I presume it's just not purely about a resourcing issue. Does the Minister have any concerns, as we do in the SDLP, over elements of the proposal like the retention of national security vetoes over disclosure to families, the protection of hard-won inquests, human rights compliance, the strength of statutory oversight and the independence of both the Legacy Commission and the Legacy Unit within An Garda Síochána?
Well, there are a number of issues with which I would express some concern and some agreement with the member at a party political level. However, at a departmental level, my main concerns are interference with judicial independence, which I think the use of the Advocate General as a backstop will do. I think there are also issues in terms of direction as to how the coroner should run an inquest, which again, for me, is crossing into issues of judicial independence. There are a number of elements of this that I have concerns about, but I do think fundamentally there is no point in us raising expectations when it comes to victims. They have been raised and dashed repeatedly over many years. The only way this will work, if it is to work at all, is if it is properly funded and resourced so that people within a reasonable time frame can get the answers to the questions that they're seeking answers for. And I think that to under-resource this from the outset will simply ensure that it will not work, it will not be a success. I do think that there are other issues, as the member has rightly said, around independence and also around the engagement of the Irish Government. But those are ones that at a party political level we will raise. At a departmental level, I'm focused on those issues which fall within my remit.
Owen Tennyson.
Thank you, Mr Speaker, and thank you, Minister, for your answers so far. Minister, would you agree with me that some of the positive changes in the legacy bill will be undermined if inadequate funding is provided?
I agree with what the member says. Dealing with the legacy of the Troubles has never been properly funded by the UK Government. No dedicated funding has been provided to the Department of Justice for the implementation of the Northern Ireland's Trouble Bill. No additional UK Government funding has been signalled to us either. It appears that the expectation of the Government is that any responsibilities falling to the DOJ, the PSNI, the Coroner Service or other devolved bodies should simply be met from within existing budgets, which, as members know already, are under significant pressure. The absence of additional funding means that delivery would have to be prioritised against other statutory commitments, and it will inevitably affect the pace and scale of operational work, adding to more distress and delay to victims wishing to avail of the new arrangements and slowing down justice for the wider cohort.
Linda Dillon.
I can call you and thank the Minister for the answer so far. Minister, do you agree with me that in the absence of this bill, that there is absolutely no reason that the British Government could not fund PONI and PSNI in terms of legacy cases, so that those cases could be dealt with right now in this time, because PSNI do not have the resource in order to fund those legacy cases? It happened whilst there was direct rule and they should be paying for it.
Minister.
Well, there is, I think, a significant issue both in terms of the remaining inquests, which don't fall within the scope of the legacy arrangements, and also a significant burden which will be placed both on a PONI and the PSNI in terms of actually servicing the needs of the Legacy Commission. So as the Legacy Commission's costs will be met in full, those organisations that will need to adapt their practices in order to service that body will have no contribution made to their costs. That will come out of the same pot as all of the other work that they do. And I don't think that that is fair. I think victims and survivors have already had to wait too long for answers, and a lawful, workable legacy framework is absolutely essential. I do welcome the efforts that have been made to improve on what the previous government had tried to introduce in terms of information and accountability. However, I don't want further uncertainty around this, particularly when it comes to funding, nor do I want the police, PONI, the Coroner Service and the courts castigated when they're unable to meet the expectations of people who are desperate for information and then find that they haven't got the funding to deliver.
Brian Kingston.
Given your public utterances regarding innocent victims and your party colleagues adopting language such as non-combatants to describe victims of terrorism, will you take this opportunity today to repair trust with the innocent victims?
Well, I think if anybody listened to exactly what I said with regard to innocent victims, they'll be well aware that I said that there was no equivalence between those who broke the law and those who were injured at the hands of those who broke the law. That having been previously a victim did not make you unaccountable for what you had done, and that you should still be held to account. It was not an excuse. So I think instead of twisting my words, the member would do well to read the entire content of what I said in that interview. When it comes to repairing trust, I have already engaged with victims' organisations and with individual victims, because much of the mischief making that went on about that interview was wholly and utterly upsetting to those who were led to believe I said things that I did not say.
Question 4 has been withdrawn. Oh, sorry, Mr.
I understand the distress that families can feel where a pseudonym is used in a domestic homicide review or DHR rather than the real name of the perpetrator who has killed their loved one, particularly where the family of the victim has waived their right to anonymity. However, the fundamental purpose of a DHR is to learn from domestic abuse deaths so that agencies can strengthen their responses to domestic abuse victims and their children, and thereby reducing risk of future incidents. The DHR is not undertaken as a means to hold a perpetrator accountable. That is a matter for the courts, and there is no additional value to be derived in terms of identifying learning in a DHR report by naming perpetrators. Domestic homicide reviews in Northern Ireland are established in statute and underpinned by the multi-agency guidance for the conduct of domestic homicide reviews, which all participants are required to follow. The guidance makes clear that reports must be anonymised as far as possible. Even where a family waives its right to anonymity and where the courts have found a perpetrator guilty, there is a legal obligation to balance the data protection rights of any living individual included in the DHR. The situation is similar in other jurisdictions. For example, in England and Wales, the vast majority of DHRs have been pseudonymised, and on occasion, where families of victims have waived the right to anonymity, a pseudonym has still been used for the perpetrator.
Mr. Beattie.
Mr. Speaker, and I thank the Minister for that. And I have to say, domestic homicide reviews are a good thing, and I absolutely welcome them. But the Minister said that there's no benefit in naming the perpetrator when the victim's name has been known. But my argument would be, for public confidence, there is a reason why we should name that perpetrator in that particular issue. Would the Minister just review that decision on that legislation?
Minister.
Well, it is something I've looked at because unusually we have had a recent case where a family waived their right to anonymity, and so the question arose that the perpetrator in the DHR would be offered anonymity when the victim was not exercising that anonymity. However, having reviewed it, I still believe that there is nothing to be added to the process. This is not about holding someone accountable or guilty. It is about finding out whether the individual services that were involved in that person's life before the homicide could and should have done better, and what lessons can be learned as a result of that. And so I think that simply using it to name a perpetrator would do nothing actually for public confidence. What will do something for public confidence is when people see the lessons learned from the DHRs being implemented in practice and better outcomes for victims.
Con Egan.
Thank you, Minister. Can I ask what work your department is undertaking to address the learnings that emerge from domestic homicide reviews?
Well, in terms of what we do in the department, it's for each of the individual organisations that are involved to look at what they need to implement as a result. But we do have regular check-ups to make sure that the learning from one domestic homicide review will carry forward and be taken forward and implemented. Some of those will have already been addressed in the interim period where there have been changes, for example, in procedures and practices in those organisations. But ultimately it falls to each of the individual, whether that be the Trust, whether it be the PSNI or whether it be some other body, to ensure that they actually implement the recommendations that are there. They are, as I say, regularly discussed and updated, and it is important for me that the overarching learning that comes from those domestic homicide reviews is taken on board for future protection.
Question 4 is withdrawn. I call Philip Brett.
In Northern Ireland, a life sentence is already mandatory in any murder case, and in circumstances considered appropriate by the court can be imposed where a defendant, like those in the Harper case, is found guilty of manslaughter. Current sentencing guidance also specifically addresses the aggravating effect of attacks on public servants, where the victim is engaged in providing a service to the public, and sentences are expected to reflect that. My planned review of further sentencing issues will consider the need to make provision equivalent to Harper's Law in Northern Ireland. I intend to commence this review before the end of the year. As we discussed when we met about this issue in the last number of months, I do not plan to include provisions equivalent to Harper's Law within the forthcoming sentencing bill. However, the bill will create a new offence of assaulting a person providing services to the public, performing a public duty or providing a public service, which will serve as a deterrent to attacks on public-facing workers, including police officers.
Mr. Brett.
Thank you, Mr. Speaker, and I once again thank the Minister for her answer. I listened, Minister, with interest to your interview today on the Nolan Show, where you highlighted some of the barriers to police officers joining the force and how we need to make sure that our police service is reflective of all sections of our community. With that in mind, Minister, would you give consideration to support an amendment in my name that would introduce Harper's Law here in Northern Ireland at your forthcoming bill to ensure that police officers here in Northern Ireland have the same legal protections as their counterparts in the rest of the United Kingdom?
Well, obviously, whether the member decides to bring forward an amendment is purely a matter for him, and I would have to consider the nature of that amendment. I'm not opposed to the issue of Harper's Law, as I think I discussed with you. I think the issue is that it hasn't actually been used anywhere where it's been introduced. So, in effect, it puts on paper something in statute that isn't actually being operationalised in practice. And my concern would be that you may find situations where, if you make it mandatory, people will be charged with a lesser offence in order to avoid the mandatory sentence, which I think has a potentially deleterious effect on prosecution. I would be quite happy, though, to continue to engage with the member about this. I can't say for sure the law hasn't been used. I can simply say that to date we have not been able to see any case in which it has been deployed in England and Wales. Thankfully, that may be as a result of there being very few manslaughter cases of police officers, and so that may be one of the reasons. But I'm certainly happy to continue to engage with the member regarding the sentencing bill. But if not there, I believe that the sentencing review, which should be launched later this month, will be a good vehicle for us to test opinion on that issue.
John Burrows.
Thank you, Mr. Speaker. In 2013, one of my own officers and colleague, Philip Reynolds, was killed by a career criminal, Shane Frame. He rammed her in a police car, was convicted of manslaughter. The sentence he got was paltry. It was a minimum term of 6 years. He was out not long after that. Would you urgently review your thoughts on Harper's Law and make it an absolute priority to protect our police officers from paltry sentences like that?
Ultimately, the sentencing available for manslaughter includes a life sentence, and the decision as to what is actually handed down in any individual case will be up to the judiciary, who are independent and have to assess all of the elements of the case, whether there was intent, for example, in addition to whether or not the act actually took place. So that's a decision that will always have discretion, and I have to say that even were we to introduce Harper's Law, we would still have to introduce it in a way that had exceptions, because that would still have to allow for judicial independence and judicial discretion. That is the nature of the system, and it's important that we respect that system. But I have to say that I'm very clear: no police officer doing any police work should face any assault when they're out there helping the public. When you attack a police officer, you are not just attacking an individual, you're attacking a whole community who are no longer able to be served by that officer. You're draining resources away from the PSNI at a time when they need them, and you are disrespecting someone who is putting themselves in the front line to keep other people safe.
Justin McNulty.
Thank the Minister for her answers thus far. If the Minister is refusing to include Harper's Law in her forthcoming sentencing bill, what measures will she take to strengthen the sentencing guidelines for anyone convicted of the manslaughter of an emergency worker on duty, including police and prison officers, firefighters and paramedics, while carrying out another crime?
Well, the first thing to say is that I'm not refusing to do it. I would be unable to do it because the sentencing bill has already been decided by the Executive, passed by the Executive in its current form, and is now in the late stages of drafting. So that's the first thing to say. I have already indicated that I'm happy to engage with the member who has raised the issue today. And if a private member's motion were to come forward in that regard, I can discuss with him the limitations and give some suggestions around how that may be done. It does, however, sadly deprive the right of the Assembly to fully scrutinise it and the right of the public to be consulted on it, and I think we're all aware of how important that is. In terms of the seriousness of these offences, well, I've first of all already mentioned that we are looking at an aggravated offence to be introduced as part of the sentencing bill, which will focus on public sector workers and those delivering a public duty or public service. I think that that will be helpful. It is already an aggravating factor to attack a member of the emergency services, and that should be taken into account in sentencing. However, to be clear, sentencing guidance is not for the department, it is for the Lady Chief Justice's sentencing group. They are the people who write the sentencing guidance based on case law and also based around the legislation which we pass, which usually sets a maxima and then allows them to interpret that within individual circumstances.
Ciara Ferguson.
Speaker, question number 6.
My department published a new restorative justice practice standards and accreditation framework on the 17th of October 2025, which will govern the delivery of future restorative justice work for accredited organisations and practitioners. The framework development has been taken forward in partnership with our protocol lead and a restorative justice working group with statutory, voluntary and community sector stakeholder representation who considered and agree the core elements of the new process. One of the key changes is the introduction of organisational plus practitioner accreditation, which was first outlined in the 2023 Restorative Justice Protocol. The three practitioner accreditation layers are Level 1, Foundation, Level 2, Intermediate and Level 3, Advanced, with each requiring increased levels of experience and training. Level 1 practitioners will undertake restorative work in response to incidents that fall beneath the criminal justice threshold, but have the potential to escalate to the attention of the police. Level 2 practitioners will undertake restorative justice work relating to formal criminal justice cases, and Level 3 practitioners will be accredited to facilitate restorative justice processes relating to sensitive, complex and serious crimes. The level awarded will be determined by the practice experience of those applying. The accreditation application window opened on the 17th of October and closes this Friday. The protocol lead and an independent suitability panel will then assess the applications and make recommendations on the appropriate level of accreditation determined on an individual basis. This recommendation will be considered and signed off by a senior official in my department. A register of accredited organisations and practitioners will be published on the Department of Justice website in 2026 when this current round of accreditation is complete.
Ms Ferguson.
Thank the Minister for your answer thus far. Minister, was a presentation from NI Alternatives and Community Restorative Justice Ireland there recently in the committee. It felt as if they were being pushed to the peripheries of the Department of Justice new system, despite being accredited since 2007. Do you not feel it could be more beneficial to lean on their expertise, particularly for complex and sensitive cases, whether it's from a community or criminal justice perspective? Thank you.
Well, we have lent very heavily on their expertise, and I think it's important to note that they were part of the panel which we engaged with when designing this system. Much of the work that they do will still be the same work that they will do post this accreditation, but there are other organisations and individuals out there who can also offer restorative practice. There is also then the opportunity for those organisations who are already engaged in restorative justice to be able to upskill their workforce, to be able to upskill their individual practitioners, and hopefully be able to assist us in actually being able to deliver restorative practice. Restorative justice will still be delivered by community-based accredited practitioners using the same values, principles and practice standards that have underpinned restorative justice in the community. As evidenced by youth conferencing, however, the criminal justice system gives access to more victims of crime who will be offered the opportunity to participate in restorative justice. That's in line with the Victims' Rights Directive, but it also requires us to ensure that there is a pathway, particularly for those most complex of cases, which many restorative practitioners to date will not have had an opportunity to engage with.
Ms Bradley.
Thank the Minister for her answers so far. But Minister, can you allay the concerns out in the ground that the new accreditation framework will not lead to unprofessional and undesirable people being accredited, undermining many years of hard work in this field?
The purpose of this accreditation process is to ensure that each of those people who are saying that they are accredited by the department and each of the organisations that are accredited by the department have a regular review of their practice standards, have a regular review of any new learning that they have, any new qualifications, and that they are kept up to date with the latest practice. And I think it's really important that if people decide to take a restorative route through the justice system, that they can have as much confidence in that route as they would have in any other route through the justice system. And so it's important for me that those people are adequately accredited, adequately inspected, and that we have a situation in which the public can have full confidence. That is the purpose of the work that we've done.
Stuart Dixon.
much, Mr. Speaker. Minister, thank you for your answer so far. Minister, could you outline to the House what the benefits and indeed the evidence of that benefit is with regards to the impact of restorative justice approaches?
Well, there are a wide range of benefits that are linked to delivery of restorative justice. It's a victim-centred approach to start with, within which they have the chance to hold a perpetrator directly to account, to ask important questions and also to share with the perpetrator the impact of the harm that has occurred to them. And that can be a transformational experience on both sides. Victims can also witness direct accountability from the perpetrator and influence how the harm will be repaired. And so very often that feels a much better process than one perhaps where victims feel that it has moved beyond their control and that they become almost a bit player in what happens within the justice system. And that's a complaint that I think we will all be familiar with. In terms of out-of-court disposals, for some suitable cases, it can reduce victims' involvement in very lengthy and stressful court proceedings. It better allows perpetrators to understand how their actions have affected their victim, their community and themselves, and those closest to them. Perpetrators also often appreciate the opportunity to meet their victim, to actively participate, express remorse and try to make things right. That can help them to identify what they need to avoid further offending and get the support to do so. Our research shows too that perpetrators have positive attitudes towards police and law enforcement, generally when they do a restorative justice intervention. I also think it can strengthen the relationships between police and community, where police are seen as facilitators of justice and not just enforcement.
Stephen Loughlin.
The Ending the Violence Against Women and Girls is a cross-executive priority led by the Executive Office. My department, alongside the Department of Health, leads on the Domestic and Sexual Abuse Strategy, which is gender inclusive and recognises that these harms can affect anyone. While my department does not hold specific data on progress against the wider Ending Violence Against Women and Girls strategic framework, we continue to work closely with the Executive Office to support delivery of its objectives. However, it's important to recognise that violence against women and girls goes beyond domestic and sexual abuse and encompasses a broader spectrum of harms, which is why the Executive Office leads in that work and on the associated data collection. Alongside the Domestic and Sexual Abuse Strategy launched in September 2024, my department has published a comprehensive performance framework to monitor progress for all victims of domestic and sexual abuse. Work is underway to agree the approach to identification of baseline data and data capture to inform future reporting cycles, which will enable us to measure both how much we are doing and how well we are doing it on a consistent financial basis. However, the data collected under Domestic and Sexual Abuse Strategy will relate to all victims of domestic and/or sexual abuse, regardless of gender.
McLaughlin.
Thank you, Minister, for your answer. And ending violence against women and girls is, of course, a cross-government priority. But the PSNI launched the Tackling Violence Against Women and Girls Action Plan in September 22, and then obviously the Executive, the Strategic Framework of Ending Violence Against Women and Girls in September 2024. Surely it's really important that if we know that these two action plans are actually working, that we would know the data and that we would be tracking it on a daily basis.
Well, the data is being tracked. The PSNI track the data that they have, and that's an operational matter that the Chief Constable is engaged in routinely and held to account for, I'm sure, by the Policing Board. And TEO will track the data in relation to the strategy, which is executive-wide. My department clearly will have inputs into that monitoring, but we are not the sole repository of all actions around protecting women and girls or ending violence against women and girls. We will play our part, but every department needs to look at those issues and feed into that overall reporting. So we don't hold the data, TEO hold the data.
Paula Bradshaw.
Speaker, Minister, can you please outline the work that your department has undertaken to design and implement domestic abuse protection notices and orders? Thank you.
Minister.
Well, we have, on the request of the Assembly in the Domestic Abuse Act, we have now got extensive preparatory work undertaken with PSNI and voluntary sector partners to design a Northern Ireland specific DAPO and DAPIN model. That will be both effective and also operationally deliverable. Engagement has provided a very strong foundation, but we do need to do further work with Northern Ireland Courts and Tribunal Service and the judiciary around the operational processes and court handling arrangements. Cross-agency collaboration has ensured early identification of resolution of key operational, IT, procedural and safeguarding requirements. We have also learned from other jurisdictions, Mr Speaker. There has been a detailed fact-finding visit to Croydon and to Greater Manchester pilot sites, as well as engagement with officials in Scotland. That insight has enabled officials to refine the model to avoid the challenges that were experienced elsewhere and to ensure that it is tailored to local needs and understands the operational responsibilities around local structures. We would hope to bring forward necessary regulations in spring 2026 and, subject to Executive and Assembly approval, the preparatory work places us, I believe, in a strong position to begin piloting DAPOs and DAPINs in the second half of 2026 or early 2027.
Emma Sheeran.
Neil, the whole question 9, please.
Minister.
Tackling delay is one of the biggest challenges facing the criminal justice system and has been identified as a key priority by me as Minister and indeed the Criminal Justice Board and justice agencies. The speed that domestic violence cases progress is of huge importance to victims, witnesses, the accused and indeed for their families and the wider community. The delivery of the Speeding Up Justice programme is a programme for government commitment which supports its Safer Communities priority. This programme is a joint cross-justice collaborative effort under the direction of the Criminal Justice Board, upon which the senior leaders of the criminal justice system are represented, including myself, the Lady Chief Justice, the Chief Constable, the Director of Public Prosecutions, the Director of the Northern Ireland Courts and Tribunal Service, and a number of senior other officials, including the Victims Commissioner. This programme takes a whole system approach focusing on reducing avoidable delay, reducing demand, freeing capacity and facilitating more proportionate and effective responses to offending behaviours. It's also aiming to take advantage of technological developments to improve operational processes and the communication between criminal justice organisations and the public. Earlier this year, the Department secured £20.5 million of transformation funding to support delivery of the programme. This funding is already being used to accelerate ongoing work in the early engagement and out-of-court disposals projects and is a significant boost to progressing this very important programme of work.
Minister, I know that during the last mandate the sector welcomed the passing of the Domestic Abuse and Civil Proceedings Act, but as I understand it, not all of the elements of that bill have been implemented, and particularly around coercive control and how incidents are often treated as single incidents, which is leading then to, I suppose, a delay in perpetrators being brought to justice. I wonder if you could advise upon what you're doing to implement all elements of that bill.
Well, the major outstanding bit was DAPOs and DAPINs because we weren't actually prepared to be able to do the regulations in the timeframe that the committee had set out in their amendment, and because there were serious concerns about their operation in other jurisdictions. With regard to coercive control, the coercive control elements of the legislation is operable and is working at the moment. The question, I suppose, is whether or not people are adequately trained and supported to identify coercive control of all different kinds. And so it's something that I will often feed back to colleagues in other parts of the justice system, where victims have come to me and said that they felt that, for example, their financial coercive control was being dismissed by PSNI as simply a civil matter that they needed to take through the civil courts. There is more work, I think, can be done around training, but as you know, annual training is part of the bill, and therefore we have, or the Act, I should say, and therefore we have the opportunity to revisit that with colleagues in the actual operational side to make sure that where we feel there are gaps or trends emerging, we can actually close those gaps through training.
On to topical questions, I call Patsy McGlone.
Minister, can you update us, please, on the potential for a PSNI pay agreement?
So in terms of PSNI pay, members will be well aware that there has been an ongoing debate this year. So there are two elements to PSNI pay. The first is their contractual element, which has been paid, and that is a legal entitlement. The second is the advised uplift from the PRRB, and that uplift is technically a discretional input. However, from my perspective, I believe it is essential that the PSNI's pay keeps pace with that in other jurisdictions in the UK, and that we're able to effect that pay increase as soon as possible. PSNI are currently indicating that they will have an overspend at the end of the year. It's a relatively modest overspend at this point, and it has been coming down steadily over recent months. I have worked with the Department of Finance for a number of issues, but I understand, given the rather disastrous budget, certainly in Northern Ireland terms, last week, that we will not have the level of Barnett consequentials that we had hoped. However, we have made other provision, both within PSNI and within my own department, in terms of potential savings that we can wring out of the budget we have at this point in the year. I am confident that before the end of the year, certainly before the end of the financial year and ideally before the end of the calendar year, we will be in a position to approve PSNI pay as affordable. But there is still significant work to be done, and I don't want to get ahead of myself before I go to executive and see what the December monitoring round might hold. But if we get the amount of money that I was indicated I would have first call on, which I believe is available, and if that promise is kept, then I believe that we're in a very good position to do so.
Mr. Badlone.
Minister, and I hear a number of caveats there, but can you guarantee that that uplift, as you referred to it, will be to the satisfaction of the PSNI officers who are currently awaiting it?
Well, my duty is not to do it to the satisfaction of PSNI officers who are currently waiting. My duty is to implement the recommendations of the PRRB. So I have no idea whether officers will be happy with what the PRRB ask for or not. But my job is to meet that requirement, because that is what maintains broad alignment with forces across the UK. I can't give a cast-iron guarantee. That would be foolish for any minister at this point in the year to get up and say that. What I can say is that the trajectory of the projected overspend in PSNI has been decreasing month on month. We have been doing some very hard work with PSNI and within the department and other justice arm's length bodies to see if there is more money that can be freed up from work that perhaps we had intended to do, but because of limited resources have not been able to take forward. As I say, I recognise that PSNI do an incredible amount of work. They deserve not just praise for what they do, but they deserve paid for what they do. And what I want to do, in conjunction with the Finance Minister and the rest of the Executive, is to be able to tell them that the pay will come and that they will be paid. And that is the most important thing I think we can do. PSNI officers should not be at the end of the queue simply because they cannot take strike action. They deserve to be rewarded for the work that they do and the sacrifice they made. It has been my objective as Justice Minister to ensure that that happens, and so far we have not ever not paid what the PRRB have recognised.
Holly Ford.
Thank you, Mr. Speaker. Can I ask the Minister just for an overview of our department's work to support the employability for those leaving the prison system?
Well, a critical element of reducing reoffending is actually how offenders leaving prison can be stabilised in the community. That means making sure somebody has secure accommodation, they have family links where that's appropriate, they have access to healthcare and, crucially, access to a job or education. Because without those things, it can be very difficult for people to reintegrate into the community. Having a job gives people more than just a wage. It gives people purpose, identity and a sense of belonging, and it allows people to be seen not just through the lens of their offending, but also what they can contribute to society, which is hugely important in terms of rehabilitation. We have invested in education provision and work opportunities in custody to increase potential for gaining employment upon release. We also provide learning and skills qualifications through Belfast Met. Employability tutors are based in each establishment, and we provide, through our VCS partners, a significant amount of work, including the Skill Set programme, which supports people. We also have representation on the DFC Regional Labour Market Partnership and work to ensure the needs of those in the criminal justice system are considered. So there's quite a lot going on there, but I think most importantly, in October last year, we launched a business-led employers forum for reducing offending. That forum will have its first official meeting on the 2nd of December, and that will be instrumental in business-to-business conversations about how you can actually employ people successfully who have an offending background. And we were really delighted that Lord Timpson was there for the launch of that, because I think it is a game changer. Mr. Speaker, I can tell businesses that it will be fine to employ somebody with an offence in their record, and they will nod and say, well, you would say that. If another business who's done it successfully tells them that, it's much more powerful.
Mr. Honeyford.
Thank you, and thank the Minister for her response. We've seen some great stuff for the hospitality, bringing initiatives like this, and during PAC, evidence adult reoffending and employability was key factor, and security of funding, that was absolutely critical. So would the Minister share with me my concern that the UK Government's failure to adequately replace the Shared Prosperity Fund could have a detrimental impact on this and the wider efforts linked to the programme of government commitment to reduce offending and also adult reoffending? Thank you.
The member's concern entirely. The lack of any kind of clear replacement for the Shared Prosperity Fund risks undermining efforts to reduce offending and reoffending. In fact, the uncertainty about what will follow from that programme really risks delivery of programmes in prison, because, of course, when you have attrition from staff who are put on protective notice in the prison situation, you can't simply bring somebody new in the next week to take up that post. They have to go through extensive clearance before they're able to work in prisons, and that could create a huge gap in the service provision that we have, particularly with the community and voluntary sector. So, I mean, I am concerned about it. I have raised it with executive colleagues. I recognise that people, I don't think, in the UK government understand just how important that Shared Prosperity Fund has been. We are engaging urgently right across departments to explore what mitigations we can put in place, and also to press for arrangements that better reflect local priorities. But it would seem at the moment that the UK government is absolutely determined to move forward with a process that I don't believe actually serves this community well.
Sir Dixon.
Thank you very much, Minister. Going forward, can I ask you for an update on your department's projected capital budget needs?
Well, if people aren't depressed enough listening to our revenue budget needs, I'm now going to depress you further by telling you our capital budget needs. Justice system is currently delivered from facilities that are often antiquated and use outdated technology. Just to give you an idea of the antiquation, in Magilligan, people are still housed in Nissen huts that were there to house Italian prisoners of war during the Second World War. So if we're going to make progress, we need significant capital investment to upgrade and modernise the ageing justice estate. Doing so will actually release savings, because we will have more efficient buildings. We will have more heat controls and more sound controls and other things, and it will actually release savings, but it will require investment. Planned capital projects for the 4 years from 2026-27 to 29-30 would cost on average £270 million each year. That would require significant additional funding above the current £100 million capital budget for my department. They reflect the costs of a number of key departmental projects for police, courts, prisons, forensic science, and many of them are included in the draft investment strategy. We have to invest in ambitious transformation programmes across the justice estate and to support and sustain investments in our estates with a focus on rehabilitation and a clear opportunity, as I say, to invest to save.
Mr Dixon.
Thank you, Minister, for your answers so far. Can I ask you, Minister, to take us through some of the potential consequences for the justice system if those capital funding projects are not funded?
Well, in terms of our 5-year plan, it highlights the need to modernise what is a very ageing estate. That's a critical element for us to make the system faster and more effective and more victim focused. For example, we will have courtrooms that don't have the ability to separate victims and witnesses from the accused, and that can create distress in some of those cases. So we won't be able to adequately meet the needs of those engaging with the justice system if we're not able to do the upgrades required. It would also reduce the department's ability to deliver future savings from the planned projects, including estates rationalisation, the use of energy efficient systems, and that capital investment will reduce the need for ever more urgent and expensive maintenance repairs as infrastructure is modernised and replaced. For those of you who watch the weather forecasts as avidly as I do during spells of bad weather, you will note how often the highest winds in Northern Ireland are at Magilligan Point. I mean, it is literally through hope and prayer that that building has held together during all of those storms, given the battering that it takes on a regular basis. And we know already some of the significant damage that was done in a previous storm where the walls of the boiler house were actually demolished by the wind. So the funding we have already secured from public sector transformation, I think, is a positive step, and that will help us. But we do need to do other things. We need new offices and laboratories at Forensic Science headquarters. They're held up internally with scaffolding in some places. We need modular accommodation for prison service because our prison population is growing. We need to modernise Magilligan and Hydebank prison estates. There is a new police college and modernisation of the wider police estate, IT transformation and modernisation projects for courts, and the modernisation of the Royal Courts of Justice and Bishop Street Courthouse, both of which are listed buildings and both of which are heavily used.
Paula Bradshaw.
Minister, can you please update on the public consultation on out-of-court disposals? Thank you.
Officials are now analysing responses to the out-of-court disposals consultation, which invited views on a number of the proposals aimed at tackling delays in the justice system. As is commonplace within the justice system, many of the offences put forward within the proposals are very broad in nature and can cover a wide range of offending behaviour, from the minor to the major. The broad nature of these cases is evidenced, including through the various options available for dealing with a case, whether by prosecution in either the Magistrates or Crown Court, which can vary very significantly in penalties. It is, I think, something to be borne in mind, because it has been raised a lot, that penalty notices will in some way be a lighter touch option. In the cases that we are recommending where penalty notices may be of use, those cases will often not be proceeded with by the PSNI because they lack the capacity to prepare the files, or because there is a lack of will, even on behalf of those who have been injured, frankly, to go through those hoops. It can often be the thing that gets dropped when it goes to the Public Prosecution Service, because they don't think that there will be an opportunity to get a significant penalty at court. And if it makes it through all those hoops and gets to court, very often it is dismissed with a fine anyway. So what we are proposing is that in those cases where a fine is the most likely outcome, that we should simply allow the PSNI to issue the fine and cut out all of that middle work, which is consuming resources and time for everyone concerned.
Ms. Bradshaw.
Minister, there's been an extraordinary amount of misinformation put into the public domain about this consultation by some parties in this chamber. Minister, would you like to take this opportunity to set the record straight again on what the consultation actually proposed in regard to assaults on police and assault occasioning actual bodily harm, and the PSNI's role in designing those proposals? Thank you.
Well, I will never shirk from an opportunity to provide clarity. In terms of the proposals, they were developed through a cross-justice working group led by PSNI. They included measures to reduce pressure on the system through additional powers for police and prosecutors to deal with lower-level offences. That included expansion of the offences for which PSNI can deal with by way of a penalty notice, which they already do for many of the cases that are listed in that. I am disappointed that people who wish to criticise the proposals are focusing solely on the more serious examples within the cohort of cases, rather than looking at those cases that could fall within that definition, but at the more minor end. Penalty notices are designed to target first-time or non-habitual offenders for a set number of offences. Once you've had a penalty notice once, you have a criminal record, therefore you can't get a penalty notice again, it has to go to court. They are a criminal penalty. It's not like as some people were describing it, that it was like getting fined for parking, which of course has been decriminalised, assault has not, and it would only affect the cases at the very lowest end of the scale. Most cases will continue to go through the courts, but one of the reasons that we're talking about this out-of-court disposal system is so that we can use the courts for the most serious cases and speed that up, and that we can ensure that people are punished for those lighter offences, which very often either get tossed out by the PPS or get a derisory fine from the courts at the end point anyway. For me, much better to allow the police officers to use their judgment, and to be clear, it will be police officers who will make the judgment, and they will have to take into account the views of the victim of any crime before they decide to dispose of it via a penalty notice.
That brings us to a conclusion. Questions to the Minister of Justice. We move on. Philip Brett has been given notice of an urgent oral question in the Executive Office. I remind members, if they wish to ask supplementaries, that they rise in their places. Clerk, please read the question.
To ask the First Minister and Deputy First Minister, given their departmental commitments to the elimination of prejudice, racism and hate crime, to confirm whether their office was represented at the event at Belfast City Hall on 19th of October 2024, at which criminal damage to a portrait of a former Belfast Lord Mayor occurred.
First Minister.
No.
Mr. Brett.
First Minister, for that fulsome answer. Institutional understanding of this place and public confidence in this place, First Minister, are based on the fact that when ministers make statements at this House, they're both true and accurate. So I'm going to remind you what you said to this House. You stated, as First Minister, on the 21st of October, a Sinn Féin employee who worked in the Assembly made the party Chief Whip aware of their involvement in an incident regarding a portrait at Belfast City Hall. You were then contradicted, First Minister, by your Chief Whip in her public statement to the PPS, where she stated that the individual responsible made no admission of either being at the event or knowing about the damage. Either, First Minister, you misled the Assembly or your Chief Whip misled the police. Both are very serious. Which one is it?
Ken Collier, there have been a number of inaccurate comments and claims made in relation to the events at Belfast City Hall on the 19th of October 2024, including at the Executive Office Committee last week. The Junior Minister said at that Executive Committee meeting last week that she attended the event as a West Belfast constituency MLA and also equally as a Gaeilgeoir. She was very clear about that statement then, so let me also be very clear today. This invitation was not accepted in the role as Junior Minister. As would be normal practice across all ministers and TEO, Aisling Riley forwarded the invitation to the private offices in order to ascertain if she could attend in her role as Junior Minister. This is the only reason that the invite is held on file. To be clear, the total information held by the Executive Office is one email, an invitation to Aisling Riley as a constituency MLA. Aisling Riley and 4 other Sinn Féin representatives received the invite. Aisling Riley, as Junior Minister, did not receive 5 complimentary tickets. This invitation was not fulfilled in the role as Junior Minister. TEO had no further involvement beyond registering the case. TEO did not provide any advice in respect of the invitation. There was no briefing commissioned or compiled from officials, and for absolute clarity, the TEO does not hold indeed any further information in relation to the events on the 19th of October.